Namaskar, hello and welcome viewers. You're watching this special presentation of Sansad TV, Bills and Acts, where we analyze bills that impact you, acts that empower you, and programs that matter to you. I'm your host Kriti Mishra, and today the spotlight is on the Digital Personal Data Protection Bill 2022. Before the detailed analysis, let's take a look at the highlights. The government has released the draft Digital Personal Data Protection Bill 2022 for public consultation. The bill seeks to govern and safeguard the use of personal data, frames out the rights and duties of the Digital Nagrik. It outlines the obligations on businesses as well. Well, the bill has been introduced after 3 months of the withdrawal of the Personal Data Protection Bill 2019. Individuals need to give consent before their data is processed, and every individual should know what items of personal data a data fiduciary wants to collect and the purpose of such collection and further processing. Individuals also have the right to withdraw the consent from a data fiduciary. The bill also proposes to set up a data protection board to ensure compliance with the bill. In case of an unsatisfactory response from the data fiduciary, the consumers can file a complaint to the data protection board. And joining us today is a very special guest in the studio, Mr. Rajeev Chandrasekhar, MOS IT. So welcome to Sansad TV, and thank you so much for joining us.
Thank you, Kriti.
Now, before I talk about the nitty-gritties of the draft, I want to understand how will this proposed legislation impact me as a user before I talk about the businesses or the powers of the government.
And I think that is a good place to start, because this bill and this draft that is now in front of the citizens of India for public consultation is a bill that will significantly alter the dynamics of the relationship between data platforms, that is internet platforms who collect data from Indian citizens, and the Indian citizen from whom they are collecting the data. So that relationship today, that has been characterized for many years by, in a sense, misuse of the personal data of many thousands and lakhs of citizens, not just in India but all around the world, is going to come to a grinding halt. This brings a certain framework of do's and don'ts for all digital platforms today that are on the platform that offer products and services to Indian citizens. They seek consent from the Indian citizens, they collect data from the Indian citizens, and then there are a large number of them that collect data that is not required and then proceed to misuse that data. And one of the ways to summarize the main reason or the main outcome of this bill is a tweet that I set out 2 days before we released the bill, which is using an example of Google Maps, which had been penalized $400 million
Yes.
For misusing personal data. I said, after the Digital Personal Data Protection Bill is enacted in India, such misuse will not be possible in India at all. Such misuse of personal data of Indian citizens will not be possible at all. So I think it codifies the rights of data principles, that is a citizen,
Yes.
and it casts very clear, unambiguous obligations on the data fiduciary, which is the platform. And in the event there is a data breach, it lays out the financial penalties and the data protection board that will compute the penalties that will be imposed on the data platform. So I think in a lot of ways it's a very simple bill. You don't have to be a great lawyer to understand the bill, and that is something that the Honorable Prime Minister has made very clear, that all of the legislations that we pass today as a government are legislations for the benefit of every Indian citizen. And to as much as possible, to an extent possible, every Indian citizen should be able to understand his or her rights that emanate from a bill.
But sir, I was going through the draft, and perhaps one of the biggest highlights for me as a reader was that in the earlier version of the bill, the focus was on localization. Now there are significant concessions as far as cross-border data flow is concerned. Why was it required? Why did that happen?
No, so look, I don't want you to start thinking, and nor do I want the viewers to start thinking, that the Digital Personal Data Protection Bill is only around the issue of localization or not.
Agreed.
There are many, many very important issues that the bill deals with. And one of the important issues is that where does a data platform or an internet platform store his or her data?
Yes.
Now, we have said, of course, there is an argument for localizing it for security purposes and so on and so forth. But given the nature of the internet and the fact that this really goes way beyond geographical boundaries, and the fact that digital trade is a reality today, and the fact that the G20 declaration talks about cross-border data flows, what we have said is in the bill is that data can be stored in jurisdictions that the government, after due consideration, will say is a trusted jurisdiction. Now, the trusted jurisdiction concept means the following, that if a citizen, Indian citizens' data is, let us say, stored in a country X, that country X will have to undertake that they will protect the Indian citizens' data as per the Digital Personal Data Protection Bill, as well as give access to data, even though it is stored elsewhere, to our law enforcement agencies if they seek to do so. So therefore, any geography that the government of India, and if the government of India turns around and says no geography, no country is going to be allowed to store data, then it will be nobody. So it is left to the government to apply its mind, apply some criteria, and to say what are the geographies, what are the countries where we can trust them to safely store data. Because look, in the internet age, every innovator, every company today wants multiple options vis-a-vis storage of data.
That's true.
They may use a cloud, they may use an Amazon cloud, they may use an Microsoft cloud, they may use an Indian cloud operator. So it is very important not to stifle the innovation ecosystem by mandatorily hard coding things like data localization.
Perhaps, absolutely, sir. Point well taken. But sir, let's also talk about the powers given to the government. Now, experts have also pointed out that these are unbridled powers. No checks, no balances. Even Justice Krishna said, and he, in fact, questioned this particular provision.
Yeah, you know, and it's a little unfortunate because I think a lot of this debate about government powers is either as is because they haven't read the bill, or the fact that they haven't understood that the Constitution, when they prescribe a fundamental right, talks also about reasonable restrictions, or that the Puttaswamy judgment that really talked about privacy being a fundamental right, and I was a petitioner for that, talks about proportionality, talks about legality, and talks about necessity. So therefore, understand in the bill there are no unbridled, unfettered powers for the government. There are certain exemptions given to the government, and those exemptions are put very honestly and transparently under a section called exemptions. And if you read the exemptions, these are exemptions for national security, these are exemptions for a pandemic, these are exemptions for a natural disaster. And let me explain to the audience and to your viewers. Can you imagine that if there is a terrorist on the run, or there is a terror attack being plotted, that you will cause the law enforcement agencies to go to the terrorists and say, may I seek your permission to take your data?
Of course not.
Let us assume there is a pandemic and there is, God forbid, another type, COVID type pandemic, and the government wants to identify and reach out to people who've got the disease or want to deliver a vaccine. Can you imagine in that chaos, the government going and saying, may I seek your consent? If there is a natural disaster and people are suffering, people are chaotic, so in certain exceptional circumstances, the government has basically said, at that time, we will go out and access citizens' data, and at that time, those rights of data protection fall away. By the way, whether it is a right to free speech under Article 19, they also have carve-outs, restrictions to right to free speech under 19.2. So these are very reasonable, very well thought through exceptions that have been given to the government to conduct what is its duty to the citizens during exceptional circumstances.
And before I get my parliamentary headline, let's take some questions from our audience.
Sure.
Please go ahead, introduce yourself and speak your mind.
In earlier draft, there existed some laws which were users friendly, like right to data portability and compensation in case of data breach of data. So these rights have been deleted now. So what's the logic behind it? And in practical terms, do we have sufficient rights?
No, look, and I want to respectfully suggest to you that you not compare this bill to the previous bill. The reason the previous bill was withdrawn, and I said it at that time as well, is that bill had become more than data protection. Now, data portability has nothing to do with data protection. Data portability is a broader issue in the data ecosystem that allows a consumer of one platform to port his or her information to another platform, which is part of what I say will be in the Digital India Act that comes in the future. That has nothing to do with the rights of a citizen to ensure his or her data is protected. So that is on the issue of data portability. In terms of compensation, look, this bill makes the process of ensuring that the consequences of a data breach is very smooth, is very straightforward, and it is done by a data protection board that will therefore levy the penalty on the breaching platform. Whether that money will be used for payout to the data principal or not is a subject matter for discussion and debate. But the fact today, this bill is not to make data principals rich. This is not the idea of data protection. The data protection law is to ensure that there is a culture of accountability within those platforms that are today collecting data from consumers and providing them a service. Yahan par, we are not interested in making a lot of money from the data platforms. We are interested in instead of making sure they do not breach the rights of our consumers. So the question of compensation to the data principal, we are silent on this does not mean that they will not be compensated. I just want to leave that thought with you.
And what happens when they breach our rights, sir?
The Data Protection Board, we have laid down very simply, the Data Protection Board will decide based on the severity of the breach, the severity of the data. They will decide whether the penalty should be 500 crores, more than 500 crores, 200 crores, 100 crores. No criminal cases, no criminalization. It's absolutely simple. It is as punitive and deterrent a measure as any bill can get. Reading this, the message to data platforms or digital platforms is simple. कि आज भारत में, if you breach the data of any Indian digital Nagrik, consequences will be swift and it will be financial and it will be significantly financial.
So in the new act, there is no distinction between critical personal data and personal data, which was there in the earlier drafts. So what's the logic behind it?
We are saying all personal data of an Indian citizen will be treated as equally importantly as critical or
data.
Sensitive. There is no need for us to start saying कि only your critical data will be protected or only your sensitive personal data will be protected. We are saying in this bill, all personal data of Indian citizens have to be protected.
Let's take another question now.
So my question is, in this section, in this draft, section 7 talks about consent and section 8 talks about deemed consent. So what are the practical implication of these two sections?
No, so the consent is a fundamental part of the architecture of data protection, which is that the consent that any data platform, and if you look at the principles of this draft, of this law, we have talked about data minimization. That means a platform can only seek from a citizen the minimum amount of data required to deliver a product or service. That means you cannot just go asking for anything. So data minimization. Then there is something called purpose limitation, which is that the data that you seek and get consent for will be only used for the purposes that you have sought consent for. Consent comes into that framework, which is if I am the platform and you are the data principal, I say, I seek your date of birth and I seek your name and address because I will deliver this service in return. These three identifiers of you have to be relevant to the service I am going to deliver, number one. Number two, I can use those three pieces of information only for the purposes of delivering that service. And that will be in the consent that I seek from you. And if you say no, I do not give consent, then frankly the service does not happen and you don't give your consent and you don't give your data. Deemed consent is very important because it works for the government. Understand that the government today, our government especially, is increasingly using data-led governance. We want to be, for example, आपने PM आवास योजना में you have got a house. But we also want to make sure that he has PM Ayush health insurance scheme. So in cases of the government, if he has given a consent for PM Awas Yojana, it is deemed to be a consent also for all of the other schemes that he or she is entitled to. That is where deemed consent comes into the picture. But effectively, the most important part of this bill is the consent. That is a right of the individual citizen, that unless I give you explicit consent, आपका मेरे से कुछ लेना देना है नहीं, मेरे डेटा के बारे में भी नहीं, आपके प्रोडक्ट और सर्विस के बारे में.
Absolutely, sir. Very imperative point there.
My question is, in this bill, we have a term data localization.
Hanji.
Means data is stored and processed within the territory. So it got some liberalization in this bill. So is it will not affect at some extent?
नहीं देखिए ये first of all, this bill doesn't talk about data localization.
Yes.
I think you are referring to the previous draft, and even that draft did not talk about localization. That draft talked about something else. I'm not exactly sure about the nomenclature. The data localization argument is that all the data generated by Indian consumers are stored in India, which implies that if I'm an innovator, I'm a startup, and I use a cloud service provider, that the cloud has to be in India. I cannot use competing cloud offerings from around the world. And that, I think, we believe is stifles innovation and restricts choice. What we have said in this draft is, while we understand the importance of data localization, while we understand the strategic interest in data localization, we must also understand that the internet cannot be localized. The internet, by its very nature, by its very DNA, by its very architecture, involves cross-border movement of data and information. वही तो इसीलिए तो इंटरनेट बना है.
Right.
तो we have said कि cross-border data flows will be conditional, and conditions are going to be decided by the government after establishing the criteria of what geography it is proposed to conditionally transfer or store the data in. And those conditions will be decided by trust, whether the law applies, our law applies in that geography, our law is applicable in that country. So those conditions will be seen by the government, and then they will say, ठीक है, India के अलावा you can also store the data in, let us say, for example, I'm just saying, USA. So that is, today the bill says it is only India, but the government of India can decide where are the other areas that it can be stored in.
Like a person goes to the bank, and a bank collects the data of the person of that person, and then the bank will have access to data, like if it demands like Aadhaar card and the PAN cards are necessary for opening the account in a bank. So I think there must be a strict, more strict liabilities for the data fiduciary.
मैंने कहा है कि कंसेंट होना चाहिए. आप समझ गए ना कि ठीक है, तो यू हैव गिवन मी द कंसेंट, आधार के लिए कंसेंट दे दिया, अकाउंट खोलने के लिए कंसेंट दे दिया. लेकिन कंसेंट में ये भी लिखा होगा कि ये जो मैं आधार मांग रहा हूँ आपका, एड्रेस मांग रहा हूँ आपका, नाम और डेट ऑफ बर्थ मांग रहा हूँ आपका, आई विल ओनली यूज इट फॉर ओपनिंग अ सेविंग्स अकाउंट. दैट विल बी इन द कंसेंट एग्रीमेंट, टू विच यू विल से yes. The principle of purpose limitation means the bank cannot use that data for anything else. Number one, if the bank uses the data for anything else and or breaches that data, that is leaks the data, they will be liable under the bill to pay a heavy penalty. Even for a normal person, normal citizen, the reading of this document makes it very simple to understand what I just said.
So we have to read it as users and be very
Please
cautious
read
about
it, and that is why I am doing this. I am meeting people and talking to groups like this, industry, lawyers, students, general citizens, industry associations, that this is a very simple piece of legislation to understand.
In the matter of Hamdard Dawakhana versus Union of India, the Honorable Supreme Court said that any policy which leads to excessive delegation of legislative powers, that shall be unconstitutional. And when we see for the first time, when we read this bill for the first time, we observe that many powers are being vested with the central government.
Right.
Whether to determine the country which is trustable or whether to determine any other aspect which is related to the collection and protection of the data. My question is, will this not be in violation of the Hamdard Dawakana matter?
So-
and
Yeah,
my
go ahead.
second question is this, that the government and the fiduciary can also collect the data when it is fair and reasonable. Now, what is the parameter of fair and reasonable?
How do you define fair and
How
reasonable?
do you
So
define fair and
I want to make
reasonable?
it very clear that fair and reasonable does not dilute the proviso of consent. Data minimization is the core principle. That means you can only collect data that is absolutely fair and reasonable for the purposes of delivering that product and service. There is a principle of data minimization, and I'll explain that a little bit more. And it has to be consented to. So it is not a question of only collecting it, but you collect it only after you receive a consent. Now, what does fair and reasonable mean? Understand one basic reality of legislating and jurisprudence in the digital space. Everywhere we are discovering as we move along, there is no written template for data protection anywhere in the world. People quote the GDPR in Europe, and I can assure you today, as having read the GDPR multiple times, GDPR is a very absolutist privacy legislation. In India, we have three objectives that we have to meet. One is, of course, consumer data protection and stopping the misuse of data. Second is continuing to grow our innovation ecosystem,
Right.
so that we don't create a compliance burden with any law and legislation. And the third is, as government becomes more and more digital, that the government must also have the ability to use its tools and use its data to deliver better governance and better reach more and more citizens. So you will see that the fundamental tenet, as law students, I can assure you today, that nothing in the digital space is static. If you quote a law or a precedent from 65 or 71 or 84, you're missing the point that in the digital ecosystem, the laws for today are going to be irrelevant tomorrow, and laws of tomorrow are going to be irrelevant day after tomorrow. Okay, so this is one point I wanted to make.
Absolutely.
On the issue of subordinate legislations and regulations, one of the important attributes or design principles, and I just want to show you how we started the process of working this bill. We started in our ministry with a document that says design principles for the DPDP bill. So we didn't wake up one day and say, क्या करेंगे बिल में? ये बड़ा सोच समझ कर एक आर्किटेक्चर बनाया है. और उस आर्किटेक्चर में a very important thing is that it is evolvable. That is, the challenges of tomorrow, the regulatory challenges of tomorrow, or whatever challenges of tomorrow, we don't have to again wake up and say, let us go and amend a bill, go through a 6-month cycle, and then
Get
address the
another
issue.
version, yeah.
Why is this important? And you are law students, and I want to share this with you. Governments all over the world have lagged the private sector in the digital space in terms of regulation and laws. That is why you are seeing for several years now large big tech companies almost brazenly exploiting consumer data and consumers.
Absolutely.
Because the laws have lagged. Why have the laws lagged? Because none of the laws, whether globally or international in India, have had the ability to evolve as technology evolves. So on this, I'm sure somebody will go to court and say Hamdard is an issue, etc., etc. वो तो ठीक है. Our explanation is very simple. Laws in the digital space have to be treated on a different footing. The architecture of laws in the digital space have to be seen through a different prism than, let's say, laws in the non-digital space. These laws have to have the ability not just to keep pace, but to constantly evolve. Now, I'll give you a classic example. I was here a few months ago for the IT rules.
Yes, sir.
The last IT rules were enacted in May 2021 after 3 months of consultation.
Yes.
And immediately in less than 6 months, less than 9 months, we came up with a new set of rules. You will ask me why? because the challenges that emerge in 6
It's
months.
a dynamic situation,
Exactly,
yeah.
exactly. It's a constantly evolving situation. So we are not at all concerned about this particular point. We actually believe that part of the design architecture of any modern law for the cyberspace has to depend significantly on subordinate legislations which will constantly evolve.
Absolutely. I'm completely out of time, but I'll give you the last question.
In the previous draft, there are 90 plus provisions in the draft, but as of now, there are 30 provisions. So my question is it sufficient to deal with the citizen of India?
In this bill, a term is being used several times, as may be prescribed. So, sir, this bill should be called as may be prescribed by the government bill. And we have seen that in India, the executive does what when they have the power. So, and this bill cleverly gives the power to the legislation subordinate, but not the actual act.
With great respect, you've been reading the wrong experts, so-called experts' views on this. And I respect your views, but I can tell you with equal respect that it is wrong. Subordinate legislation doesn't mean executive power. It has to be placed in parliament. Every subordinate legislation is tabled in parliament. ये कोई नहीं है कि हम सुबह बैठ के डिसाइड कर लेंगे कि subordinate legislation क्या है, हम we'll sit down and do it on our own. Number one. Number two, in the government, every subordinate legislation that we undertake is done with extensive consultation. IT rules, for example, the amended IT rules took 4 months of consultation. So transparency is absolutely written into how we develop laws, rules, and legislation. Number one. Number two, buy into this conspiracy theory that there are ministers and bureaucrats sitting around trying to figure out the best way to cause harm to the Indian citizen is something that my suggestion is, ये आप मन में निकाल दो. We are doing today what is required to be done to make India a $1 trillion digital economy in the next coming years.
Yeah.
We are creating these laws and rules not to give the government more powers, but to enable our innovation ecosystem and protect our consumers at the same time. On the issue of whether it should be 90 sections in a law or 30 sections, I know you're a law student and you like long, complex documents. I think this 30 section law is a far more contemporary, far more modern piece of legislation than the 90 section law was. And as I've said in the past, and I'm saying again today, the previous draft had to be repealed and withdrawn because it had become too complex, too cumbersome, and had begun to deal with too many issues that were not data protection. So obviously, if you deal with issues that are outside of data protection, so 30 se 90 to hoga hi.
Quickly, sir, when do we see this bill in Parliament? When will it see the light of day?
One of the articles of faith for our government is that we will extensively do public consultation. Jaise you've got, all of you gave your views. We will undertake these consultations all around the country. We are meeting all sections of society, get their views, because the Prime Minister repeatedly says we are legislating for the future of India, for young Indians, and therefore we must get as much of their views on board, make them comfortable about our intentions and our objectives, make it their objectives and their intentions, and then legislate. So I suspect that the earliest that we can look forward to this is in the budget session.
Budget session, not before that. On that note, thank you so much for joining us,
Thank
sir.
you. Thank you very much.
Well, viewers, that's all we have for you in this edition. Thanks for watching and stay tuned to Sansad TV. Goodbye from my side for now.